Hi everyone, hope you're having a great day. In today's video, I have an immigration update to share with you regarding a new policy announced by USCIS on issuing RFEs and NOIDs. If you don't know what an RFE is or an NOID is, don't worry because we're going to talk about that in this video, so make sure to stick around. Hi everyone. My name is Michael Ashoori, and I'm a U.S. immigration lawyer based in Los Angeles, California. At my law firm, we work with clients from all 50 states and worldwide, and we regularly post videos to make sure that you're up to date with the latest immigration news and trends. So if you haven't yet subscribed to our YouTube channel, make sure to hit the subscribe button now. Also, make sure to give this video a big thumbs up so that YouTube knows to share this information with more people. So as I mentioned, in today's video, I have an update for you regarding a new policy from USCIS regarding RFEs and NOIDs. If you don't know what an RFE is, if you don't know what an NOID is, don't worry because we're going to discuss that in this video. So let's get started. So when somebody applies for immigration benefits through USCIS, whether they're applying for a green card or whether they're applying for a change of status or they're applying for naturalization or you name it, USCIS can respond in many different ways. One way that USCIS can respond is by approving the case. Or if the case wasn't filed properly, USCIS could potentially reject the case. Or if USCIS has additional questions, they're not sure about a particular part of the case, then they can issue something called an RFE, which stands for Request for Additional Evidence. USCIS can also issue something called an NOID, which stands for Notice of Intent to Deny. And an NOID, just like it sounds, is a notice from USCIS to the person filing the application that USCIS is basically on the verge of denying this case unless the applicant or the petitioner can provide additional evidence that show that the applicant is in fact eligible and qualifies for whatever benefit that they are petitioning for. Also, in some cases, USCIS can outright deny the case and issue a denial. So what we just went over is that USCIS has multiple different ways of responding to an application for immigration benefits. They can approve the case, reject the case, issue an RFE, issue an NOID, or deny the case. So now that we have that general background information, let's talk about this new update from USCIS regarding RFEs and NOIDs. Well, basically, back in 2013, USCIS had a policy where when somebody applied for immigration benefits, USCIS could not deny the case without first sending a request for evidence, an RFE, unless there was no possibility that the person that filed the petition could get their case approved with additional evidence. So if there was any chance that additional evidence could result in the case being approved, then USCIS had to issue an RFE. It was only if the case had no chance of being approved, there was no possibility of the case being approved, that USCIS could deny the case without first issuing an RFE. Well, in 2018, that policy was rescinded. So from 2018, USCIS could deny an application without first issuing a request for evidence or a notice of intent to deny the case. So what happened was that many cases were getting denied, and the people would either have to file a motion to reopen the case or they would have to refile the case. And this resulted in additional expense and processing times and struggles for both USCIS and applicants for immigration benefits. So now for the update. On June 9th, 2021, USCIS announced a policy that they will be going back to the 2013 policy where USCIS officers have to issue an RFE before denying a case unless there is no possibility that the case can be approved with additional evidence. So this is wonderful news for people that are applying for immigration benefits because as you can see, an RFE, when USCIS issues an RFE, a request for additional evidence, it gives the applicant an extra chance to clear up any doubts or any concerns or any uncertainty that USCIS has about somebody's eligibility for a particular immigration benefit. So by USCIS having this new policy that requires immigration officers to issue an RFE unless there's no possibility that the case can get approved, it gives applicants an additional chance to correct their application and to supplement their application with additional evidence to give them a better chance of getting their case ultimately approved. So as you can see, this is wonderful news for anybody that's applying for immigration benefits through USCIS. This is an effort by USCIS to adjudicate cases more fairly and efficiently. As I mentioned earlier, when people have to file a motion to reopen their case or when people have to refile their case, it causes delays and various other logistical difficulties for both sides. So this is again an effort by USCIS to adjudicate cases more fairly and more efficiently. So as always, I hope you guys found this information extremely helpful. If you know anybody that can benefit from this information, make sure to share this video with them. At our firm, we're all about empowering people by providing more and more knowledge on immigration. So the more people that can watch this video that can benefit from this information, the better. As always, thank you guys so much for tuning in, and I will see you on the next video.